Hey guys, welcome back to today's video. In this intense courtroom showdown, we're diving into the story of a man in the middle of a heated divorce case who decides he's had enough of his lawyer and tries to represent himself, only to be firmly shut down by a no-nonsense judge at every turn. It's a clash of ego, law, and authority that quickly spirals into a dramatic exchange you won't want to miss. Let's get right into it.
This is in the District Court of Elk County, Kansas, case entitled In the Matter of the Marriage of Antonio Manuel Perez Beal and Sidney Page Simon. It's case number 2023 DM 300003. I will note that Mr. Perez Beal appears along with his attorney of record, Ronald Wood. Sidney Simon appears separately from her attorney of record, Lauren Schuler. This matter comes before the court at this time for further proceedings. Counsel, this court had conducted a trial in this case, made rulings and orders which should be journalized by now. As far as I know, the court does not have a journal entry of judgment and decree of divorce submitted as of this point. I also note that Mr. Wood has moved to withdraw his counsel for the petitioner in this case, which has actually been objected to by the opposing party. So I'm going to start with Ms. Schuler and ask her, where are we at on this case?
Thank you, Your Honor. So did you receive my exhibits?
I did.
Okay. So I did draft a journal entry. The proposed journal entry is Exhibit A. I did supply the email that I sent the journal entry, showing that I sent the journal entry to counsel Mr. Wood. I sent that on Tuesday, May 13th. As you stated, we did have trial on May 7th. I did supply as well, which is reflected in the court filing, Exhibit C, which is Mr. Wood's objections. If you look at the objections, Your Honor, unfortunately, a majority of them are not actual legal objections. They are essentially requests to change your ruling. And I can go into further detail, but I would argue 80% of them are just requests to change your ruling. They're not actual legal objections. And I think that's where we're at a standstill. I was waiting on this hearing.
What about the other 20%?
I did make
corrections
those
that are appropriate?
I did make them.
Okay.
So specifically objection 1, 3, 7, 17, and partially 14 were all made. Missing a comma or referencing specifically the parties for joint legal custody. I did make those. But outside of that, the others are requests to modify your ruling. So I was waiting on this hearing to file a motion to settle the journal entry. So that's where we're at on the journal entry. I will wait to go over my objection to the motion if you would prefer that.
So here's where things start to get even more intense. The father, clearly frustrated with the judge's earlier rulings, believes he's found a way to push back by filing a motion to have the official journal entry reconsidered and revised. As the court prepares to go through his arguments point by point, it turns out he actually raises a legitimate concern about some of the wording being overly vague and open to interpretation. But just as this is about to unfold, the situation takes an unexpected turn, because before anything else can move forward, his own attorney steps in with a request that could completely change the course of the case: a motion to withdraw as his counsel.
All right, Mr. Wood, as far as the court's concerned, the court wants to settle this journal entry before allowing you to withdraw. I do understand the nature of your motion in this case, but I do note that on behalf of your client, you filed certain objections back on June 3 to the wording of the proposed journal entry of judgment and decree of divorce. Some of these cosmetic changes have been made, apparently. I understand that your client may not be 100% in agreement with the court's ultimate rulings in the case, but what this journal entry is intended to do is to simply document what the court did rule upon. So what's the problem here, Mr. Wood?
Well, Your Honor, I received from my client approximately 4 pages of changes that he wanted to make in the journal entry. I took those at the best I could and made those objections known to the court the best I could that would not be considered frivolous or completely not allowed in this type of a review of the journal entry. So I did what I could, and then once I did that, then I received wording from my client that he was did not approve of what I have objected to, and wanted to know why I didn't use everything that he'd given to me as objections in the journal entry. So I did what I could to pare it down. What really concerned me, though, also is that I filed that on June 3rd, but on his what he had sent back to me, objecting to what I'd sent, he'd started sending copies of that to the disciplinary administrator. And so that concerned me whenever the disciplinary administrator gets involved and indicates that, she didn't want to be involved with that. So I understand the court's position on withdrawing, but I had to put forth the objections that my client in some manner objected to with the understanding that I think some of his objections really would be more of a motions for rehearing or motion for modification. And that's a little bit of a problem when people are using the internet or whatever they're using to come up with attempting to practice law. And so they don't understand the distinctions between those and the objections to the journal entry. The journal entry is supposed to recite what this court had ordered. And it's not to be the objections to what the court had or whether you agreed or disagreed with what the court ordered. The journal entry is to reflect what the judge ordered. And whenever I get something saying, no, these are all the objections I have to the journal entry, and I'm sending these copies of all this to a disciplinary administrator, that concerns me that I've got someone, watching over my shoulder. He doesn't trust my abilities to do the work that I'm doing, doesn't understand with 46 years of experience that I know what I'm doing.
Are you seriously saying 46 years of courtroom experience beats 46 minutes of Google Law School? No way. And just like that, you can already feel the tension boiling over. But to really understand how things got this chaotic, here's the backstory. The man was previously arrested over an alleged incident involving his wife. Details aside, what stands out is that even during sentencing, he was still hoping for reconciliation. Meanwhile, just a day before that, a divorce hearing took place, one he completely missed because he was sitting in jail awaiting that very sentencing. Fast forward to now, he's out, the marriage is clearly over, and all that unresolved frustration is spilling straight into the courtroom, setting the stage for everything that's about to unfold.
But if he and I cannot communicate, if he continues to think that I'm not doing a job for him, then I just figured I had to withdraw, Your Honor.
All right. Ms. Schooner, I'm going to go back to you for a moment. I trust that there's been some personal communication between you and Mr. Wood in an attempt to try to reconcile differences on the wording of the journal entry, perhaps a recent phone conversation or email chain or something?
I did call Mr. Wood. I did let him know I was going to have to object because we were still in the process of working out this journal entry. You did order for some documentation to be provided to me by petitioner in regards to picking a vehicle. So I said, hey, get me that. We did not go into the journal entry as much. I did let him know, hey, I made some of the cosmetic corrections, but your objections or your client's objections are, again, more so for reconsideration, and I'm not going to make those changes. And that was after our Exhibit D, the email including me and Mr. Wood with the disciplinary administrator, where Mr. Presbeal says he is going to file an ethics complaint against me. So not as much as I'm sure the court would prefer, but obviously with this email coming out, I believe Mr. Wood was trying to be as cautious as he could due to the situation.
All right. So the first issue before the court is settlement of the wording of the journal entry in this case. And in doing so, I'm going to try to systematically go through here and determine, is there a legitimate objection to the wording used by Ms. Schooler in what I see as, I want to make sure everyone's on the same page as to what I'm referring to. In my exhibit notebook, it's Exhibit A, which is what I believe is Ms. Schooler's most recent attempt to draft an appropriate journal entry of judgment and decree of divorce. Is that correct?
Yes, it is, Your Honor.
All right. Obviously, the comma in number 1 has been resolved. Petitioner objects to the court's finding, and the petitioner will not respect the bond of the respondent. Oh, to the extent, apparently, that the petitioner will not respect the bond of the respondent in this matter. If that's consistent with a ruling from the bench, and I think it is, then that's not objectionable. Okay.
May I make a statement?
Mr. Perez-Beal?
Yes, sir.
So
That's me.
What's your statement?
My concern here is several things in the journal entry are not written how the court ordered. I have recently filed for a transcript request for the judgment in this case. I've paid for that and I have a receipt for it. And a lot of the wording affects the legality of the court's judgment. And when it comes to getting involved with disciplinary administrator, I done that because Mr. Woods failed to address our son getting bit by a dog while in his mother's care, failed to address Sydney not showing up for
Okay, we're getting off the path here.
Twice.
We're getting.
No, sir, we're not.
Okay. All right. Regarding number 2, the court will overrule any objection to this finding. Mr. Simon's actions in, as I recall, taking possession of the child at a bus stop, that alone gives this court pause and some reason to make a finding that the court has concern that Mr. Perez-Beal will not respect the bond of this child with his mother.
That was during my.
And there are other
parenting
reasons. However, the court finds that the objection is overruled as to number 2. Number 3 apparently has been corrected. As the court recalls, there was a protection from abuse case previously between these parties. The court finds that even though Mr. Perez-Beal may deny that there was ever any abuse by him, the court does find that that's an appropriate finding for the court to make. And the court will overrule the objection to number 4. The court also finds that there has been difficulty between these parties based on the evidence to effectively communicate regarding setting a parenting plan or deciding many important matters concerning this child. So the court does find that there's evidence in the record.
messages.
All right, if you interrupt one more time, Mr. Perez-Beal, we're going to mute you or take you out of the meeting completely.
Yes, sir.
Judge Ricky is clearly not someone you can rattle. He runs a tight courtroom, and it shows. As you'll notice throughout the rest of this exchange, every time the man tries to interrupt, argue, or throw in something off track, the judge doesn't even entertain it. He simply brushes past the noise, stays focused, and keeps the proceedings moving without missing a beat. It's a masterclass in control, and it quickly becomes obvious who's actually in charge here.
So the court does find that there's evidence in the record to support that finding of number 5. Objection number 6, objecting to paragraph 13 in the school district should be USD 232.
Your Honor, just so you don't have to pull up the, Google it, USD 232 is DeSoto, Kansas, which is up towards Lenexa.
282.
All right, so number 13.
A lot of the objections.
Why is that a problem?
A lot of the objections he made are not what I requested, and I'm getting ready to submit that.
All right.
What I have requested to him.
Okay, I think the children do attend West Elk schools, correct?
Yes, sir.
Okay, so what's improper about 13?
He
don't
has
see any
manipulated
problem
my
there.
objection request.
Okay. I don't think we need to put the USD number in there. I think the term West Elk Schools is specific enough. I'll overrule any objection to 13. Number 7 apparently has been corrected, Ms. Schooler.
Yes,
In
it has been.
paragraph 26.
Yes, I did make that correction.
All right. That appears to be consistent with the orders and rulings of the court as it currently reads. Objection 8. Is there some dispute about the amount of child support to be entered into the record here?
Yes,
Yeah.
sir. There's been 3 child support worksheets entered on this without a chance for me to do taxes and submit financial records. And her most recent one states it was filed in, I believe, June 13th
Okay, well,
or May 13th.
okay, wait a minute. Let's back up. Mr. Wood indicated in his objection that I ruled from the bench that I was specifically adopting a particular child support worksheet that called for an amount of $1,383. So why wouldn't that be appropriate, Ms. Schooler?
Your Honor, because you did not adopt a specific worksheet, we imputed Mr. Perez-Beal's income at $58,000. I think $230. I might be off on the last few dollars, but he was
58,320.
imputed. Correct. And I had to make the tax adjustments, so there was no actual worksheet adopted because I had to make a change. But he was imputed by you, or his income was ruled upon that it needs to be imputed. So the February 12th worksheet does not have the imputed income because we were never provided that information.
There was never no paperwork filed to omit the previous child support worksheets that were submitted with a file stamp.
And just when you think the arguments couldn't get any more tangled, he doubles down with a confusing claim about paperwork and proper stamps, essentially contradicting himself mid-sentence. But the judge isn't having any of it. Cutting straight through the wordplay, he points out that most of the objections aren't about facts at all, they're about wording. And with a sharp, no-nonsense tone, he challenges him to do better, making it clear that if he's going to argue over language, he needs to actually understand and use it properly. It's another moment where the courtroom tension spikes and the judge firmly reasserts control.
One of them by Miss Simon herself with a self-litigant form that she submitted with it. And, Your Honor, I'm getting ready to file a motion and lay out a lot of things that have gone on here that I believe Miss Schooler and Mr. Woods are discussing and kind of having backroom conversations. Mr. Woods' motion to withdraw on our inability to see eye to eye on this is false. I use a phone recorder, and Mr. Woods previously told me, I believe it was the 10th, that he demanded $7,000, and if I didn't pay, he was gonna withdraw.
All right.
So,
Okay,
extortion.
I'm really just focusing on the child support worksheet, one issue at a time. I don't see your proposed worksheet, which calls for that amount. Ms. Schooler, it doesn't appear to be an attachment to your journal entry.
What about the one, the respondent
Okay,
file?
Mr. Presbyl, be quiet for a moment.
December 20th.
I'm addressing Ms. Schooler. The worksheet that you're depending upon to justify your amount in your proposed journal entry, which is a couple $100 a month higher than what Mr. Wood's objection stated it should be. So where is your worksheet?
Your Honor, I believe because that wasn't a legal objection because you already had ordered for his income to be imputed. I didn't include it, but I am going to pull up my notes from the hearing that I have right here.
Well, that worksheet would need to be filed with the decree.
Right. Because you had already ordered for his income to be imputed.
True.
And
What the
changed
court often does, counsel, is to set the building blocks necessary to put the worksheet together. I hope to always settle those building blocks without determining the actual amount. That really is a mechanical computation. Once you know what to plug in, essentially the worksheet software does it from there. So I don't fault you in all respects here, Ms. Schooler. It's just that whatever worksheet is eventually generated based on the building block orders that this court has made, that needs to be included to support the child support amount, which is in the decree of divorce. But you're telling me that once you had adopted all the income numbers and put all the proper inputs in, it came out at $1,569 a month?
I do believe so, Your Honor, yes. I'm going to try to find it in what I sent to Mr. Wood.
And I may have adopted certain numbers out of a child support worksheet that had been submitted, but I think if there were any adjustments that needed to be made to the worksheet for any reason, tax exemption adjustments or anything, then I couldn't have settled or finalized the child support number at the hearing.
No,
That's why
you wouldn't have been able to,
requesting
Your
a
Honor.
transcript.
Because you will see in the my proposed journal entry, you specifically stated, I'm going to find that paragraph for you, that his income must be imputed at that number because he had not provided any income information, and you felt that that was a good number for his trade skills, the kind of work that he does.
Imputed at what number?
$58,320.
That's what your child support worksheet says, but it says date submitted May 13th. The one you submitted on February 12th says $13,833, and on the child support worksheet the respondent submitted December 20th of 2023 states where we agree on no child support at all.
Well, none of those
for
past
taking
worksheets
care
mean a
of
thing right
children.
now. What the court's concerned with was what was presented to the court at the trial and what numbers this court ordered be put into a child support worksheet to generate the eventual child support amount.
Your Honor, it's
I believe it was the one
Okay,
from
just a
February
minute, Mr.
12th.
Perez-Beal. Again, Ms. Schooler, you have the floor.
paragraph 29 of my Exhibit A is where I reference you imputing the income, what you imputed at, and why you imputed it that way.
All right. Well, again, Ms. Schooler, it's just difficult for the court to adopt a worksheet number when I don't have the worksheet.
I do apologize about that.
But presupposing that you do have a proper child support worksheet, which places the numbers in that was found by this court to be appropriate at time of trial, if that's how it comes out, that's how it comes out. Now, what did you do with the tax exemption benefits, Ms. Schooler?
Your Honor,
What did
he
you
was
contemplate?
given a $203 credit because my client would have been able to claim all three children for the year 2024. There is also a daycare cost in the amount of $500 that my client pays. So father was imputed $500 for childcare, and then he was given a complete income tax credit for all three children.
Mm-hmm.
On the numbers per age on children, you have two children between the ages of 6 and 11 and one under the age of 5 or 0 to 5. Right now, at the time of this document, we have two ages 0 to 5 and one age 6 to 11. And where is the $500 child care? Where can I find that, Ms. Gruler?
Your Honor, do you want me to try to sort this out? I just don't want to.
Is it included on the proper line?
Yes, it's in paragraph G1 on the worksheet.
Okay.
And for the child support guidelines, when the child is over 6 months or close to 6 months, they
what you have.
to the next age group. So I can't control that.
All right. I'm aware of that provision, counsel.
Your Honor, may I have time to file the past 2 years' taxes that a previous attorney told me to wait until this issue was resolved to file my taxes?
No.
Yes, sir.
We're settling today's journal entry based on what was presented and ruled upon at the trial of this matter.
I'm objecting to the journal entry being finalized today.
And then comes one of the most sarcastic and cutting moments in the entire exchange when the judge fires back with, well, I'm objecting to you stealing my oxygen. But we don't always get what we want, do we? It's a sharp, almost humorous shutdown that instantly puts the man in his place while reminding everyone in the room who's in control. The tension breaks for a second, but the message is crystal clear. Baseless objections and pointless interruptions aren't going to get him anywhere in this courtroom.
You can object all you want, but if the court determines that it can settle the journal entry today, it will.
This is a hearing for withdrawal.
We can't just hold up this decree indefinitely because you object to some of the rulings that the court made.
That's why I have requested it. That's why I'm getting the transcript.
What we're trying to do today is properly document the court's rulings. You can disagree with those, Mr. Presbill.
Because that's what
you may even be able to take further legal action concerning them, but at this juncture, we're just trying to settle the journal entry.
When it comes to on the journal entry,
all right.
Ms. Schuler used a fraudulent witness.
I'm going to tentatively adopt the language in the proposed decree because it is being represented by preparing counsel that she has properly used the numbers that the court ruled upon at the time of the hearing to formulate a worksheet. But without that worksheet before it, this court will reserve an eventual ruling until I see that worksheet as submitted in my queue with the decree. So, Ms. Schooler, it has to be with it.
Absolutely. I apologize. I just wasn't a legal objection, so I just didn't think. I thought we were going to resolve only that. So it will be submitted, of course.
Very well. So I'm going to overrule the general objection in number 8, purporting that I adopted some prior worksheet.
In Your Honor, I can read you my specific notes to you as to the income if you'd like to. Maybe that could jog your memory if you need that.
Well, I didn't attempt to send the child support number, correct?
I'm so sorry, Your Honor. He cut you off.
All right. I didn't attempt to adopt a specific child support number, as I recall.
No, Your Honor.
No, Your Honor.
It was subject to further computation and input into the worksheet.
Yes.
So the court's going to overrule the objection to the child support worksheet at this time, pending this court's scrutiny of the eventual worksheet submitted to support the number. All right. Number 9. The court finds that the best record is kept by the Kansas Payment Center of systematic child support payments. I do understand the certain benefit that might accrue to Sydney if payments were made directly to her checking account. However, I think that it's important to keep an official public record of payments made. So I'm going to require that the general provision be followed and that payments may be made through the Kansas Payment Center in accord with what we do in the vast majority of all other cases. All right. Objection 10. Child support will terminate for each child after they complete their high school education pursuant to state statute.
Your Honor, I'm in the process of filing a motion and presenting documents to the court. I really don't feel comfortable proceeding until the court has had a chance to review.
And despite all the complaints, objections, and attempts to derail the process, the hearing just keeps moving forward without hesitation. It's almost as if the court isn't concerned with personal feelings at all, only facts, procedure, and the rule of law. That realization hits hard as it becomes clear that no amount of frustration or emotion is going to slow things down or change the course of what's already in motion.
Okay. Paragraph 35. Isn't that consistent with statutory language, Ms. Schooler?
Yeah, that's what my paragraph 35 says, just more in depth and cites the statute. So I didn't feel like that change would actually hurt the journal entry rather than.
I don't think that there's any inaccuracy there. I see no need for a change. Court will overrule objection number 9, or excuse me, number 10. Okay, number 11 does appear to raise a substantive issue here. Petitioner specifically indicates that the respondent was not awarded the 2003 GMC Sierra. Respondent was given a choice. If she wanted the Sierra, then she would have to take responsibility for the debt, or she could be granted the 2003 Chevy Silverado, and that she hadn't indicated her selection.
The Sierra is a business truck that I use on my taxes, and I was awarded everything regarding the business.
The paragraph's not identified, so where is that, Ms. Schooler?
So that is going to be paragraph 38 and 39.
Okay.
And Your Honor, in Exhibit B, the email where I sent the journal entry, parenting plan and child support worksheet to Mr. Wood, I note that there are a couple highlights within the journal entry because I need to be provided the documentation in regards to the Duramax, so my client can make a decision on which vehicle she wants. I have not received that documentation, and there was an objection about it, but I sent it with highlights saying I need this information, it's subject to change. Once I get the documents, I'll let you know her selection. I haven't received those documents, and this objection was filed.
I submitted all that documentation to my counsel. Let me find it.
All right. I don't see that the 2003 GMC Sierra is addressed in either paragraph. Is that what you're... There are a lot of vehicles involved here, but I don't see a specific reference to a 2003 GMC Sierra.
I think she called it a GMC Duramax.
So I believe it's between the Chevy Silverado and then the GMC Duramax are the two options my client can pick. I think there's one in each paragraph for the time being, but when I submitted those to Mr. Wood, there were highlights on them because I don't know where to put each one yet because she hasn't made a decision because she hasn't received the documentation.
Bottom line is, I was awarded all the property in B&B Construction Services, and that vehicle is used for tax purposes. And you have manipulated the court's ruling, Ms. Schooler. The transcript will prove that. In the
All right. So
notice
Ms.
of
Schooler, I trust that the court ordered that she had some sort of choice she could make, and she hasn't made the choice?
Because there's debt tied to one of the vehicles, and you said if you pick this car, you have to take the debt, but I need the documentation reflecting the debt, and I don't have that. So she can't decide because maybe it's a significant debt. We don't know.
10,000 and something. I submitted that to my counsel. I got a pile of paperwork here. I'm trying to find it.
Mr. Wood, do you have that documentation as to how much this debt is on the GMC Sierra?
And not other than what I put in there, the amount of $10,024.20. But
Where did you get that?
I'm sure I got it off the documentation, but I can look for that, Your Honor. I just don't know that I have it with me right now, but I can send that to him.
If that's the amount of the debt, what would your client's election be then?
I believe she would want to take the vehicle. Is that correct, Ms. Simon?
Yes.
Even though it has that kind of debt on it?
Yes.
Okay.
But I just obviously would like to do my due diligence and verify the debt amount. So that's why I was not able to make a selection.
What does it say regarding me being awarded property when it comes to B&B Construction Services? Can you state that, Ms. Schooler?
I'm waiting for Chief Judge Ricky.
All right.
That's getting a little long.
I hate to make you resort to this, but apparently Howard State Bank would be the creditor. May take a business record subpoena, but I think Mr. Wood, if he's got it, he'll turn it over, and the court will so direct whether he's allowed to withdraw at the end of this hearing or not. It's just a document in his possession that I believe should be turned over.
I'll look for it, Your Honor, and see if I can find it. If I have it, I'll send it to Ms. Hoover.
That's a very specific number that you stated, Mr. Wood. So I trust that you had some documentation supporting that very specific number.
I guess we could put in the journal entry that, I mean, she'll take that contingent on the debt being that amount, and or we'll get the records.
Not to exceed that amount. Yeah.
Yeah, not to exceed that amount.
Yeah. Mm-hmm.
Will the court take notice that Mr. Woods filed a fraudulent claim for his motion to withdraw? And I'm going to prove it. I have audio and a transcript of it.
Well,
And right when the situation couldn't get any more risky, a serious warning gets dropped, because opening that line of argument would be like unleashing a Pandora's box he won't be able to close. By pushing further, he'd end up exposing his own protected and confidential conversations with his lawyer, completely defeating the purpose of attorney-client privilege in the first place. It's a high-stakes moment where one wrong move could backfire badly, and the court makes it clear that some doors once opened can't be shut again.
all right. So I think you might have to rename that, Ms. Schooler. If we were talking about it as the Sierra, let's call it the Sierra, and that would be in paragraph 39, awarded to her, along with the debt not to exceed $10,024.20.
Hold on.
I am, Your Honor. I just had to find it.
Then that
So
debt,
she would be awarded the Duramax is the one with the debt. She would be awarded the Duramax so long as she is taking the debt in the amount of $10,024.20.
I say not to exceed that.
Hold
amount.
on. I found the document from the bank.
I was saying then that would be entered into her column in paragraph 41 too.
I can do that.
Now you just say, again, if you could refer to it as the Sierra.
Okay.
$10,024.20.
Okay. Has there been any payments on it since that number was turned over to Mr. Wood?
No, sir.
Oh, all right. Well, it's probably more then. Okay. So most of the wording that's there, presuming your client actually takes the 2003 GMC Sierra and the debt on it, we just need to add that debt to paragraph 41 as hers, and then making that clear in paragraph 39 that she's taking the GMC Sierra and the debt of just over 10,000 that goes along with it.
I can do that.
Okay. And I think
Your
that
Honor,
settle paragraph objection number 11. Then
I have a
12.
notice
Just-
of...
okay, hang on. We're moving on. Paragraph 12. The objection there, he wants to choose his own keepsake items and make his selections through the attorneys. Paragraph
Yeah.
59 reads,
I don't want to be left with scraps. I just want something little from each of our kids. She's already taken most of everything. She lived here whenever I was in jail in Greenwood County. She lived here, and I'm getting ready to prove
all
my
right,
children was taken away from me.
Ms.
That
Stewart,
emergency motion.
Ms. Schooler, let me address you regarding that. Now, you have some very specific language regarding what we're going to do about these keepsake items, about the respondent, your client, going through the tub of keepsake items for the minor children and grant some of those to him. Correct?
Yes, Your Honor.
Isn't that consistent with what the court said from the bench?
Yes, it is, Your Honor.
I find that to be, it's imperfect, but generally workable, and I do expect Sydney in good faith to go through these items and split them up in an appropriate way.
Your Honor, if she had
Obviously, the
good
court
faith,
doesn't
she
want to get
wouldn't have had her
involved with
father.
every, picture and possible keepsake item. I'm comfortable with the current language.
Can we address the heating and air unit
Um,
and the witness Miss Schooler brought to court that I have a current no contact order with, that she requested information for a case that was dismissed due to false allegations in that case. Missed a discovery I'm going to submit will prove he lied on the stand, and that the court adopted a fraudulent receipt that he claims serial numbers matched. I just got in touch with that company, and I have a written affidavit or email from, I forget his title, but he's a manager at the company, clarifying that the serial numbers on my receipt match the ones that he had on his records.
That's not something that we're taking up right now. I'm moving on with the objection list. I think 13 we've now covered. 14.
The objection list, Your Honor,
properties.
isn't my objection. And I object to this proceeding because it's not what I request.
And then comes the moment where the reality of the situation is laid out crystal clear, because ironically, the only reason this entire hearing is even happening is because of his own request. As the court carefully goes through each of his objections to the official journal entry, it becomes obvious that the process he's now frustrated with is one he personally set in motion. It's a subtle but powerful reminder that the system is simply responding to his demands, not working against him, and that realization adds a whole new layer to the tension unfolding in the courtroom.
Okay, why don't you include the legal descriptions?
Because I was
Two,
awarded
43
three
and
properties.
44.
Your Honor, he stated that they were provided to me. They weren't. That was going to require me to probably pay to have to get some more records. My clients' names aren't even on any of the properties, so really nothing's going to be changing. I just
Okay.
didn't add them because I didn't have that documentation readily available.
Okay. So he's already the titled owner on Cliff Street and 501 Line Road in Severy.
Yes, Your Honor.
And your client has no interest?
Nope.
Okay.
We just
And
put
then
it
he's
in there to make
awarded
sure all
the
bases.
Turkey Road property, and you did include the legal.
I did, Your Honor.
All right. Since I don't think it's going to necessarily change anything, I'm inclined to agree that I think we can, if you don't have them, to insert.
And if he can provide them to me, I'm
Mr.
more than
Wood
happy to add them, but it was going to require me to pay, my client have to pay to remedy his objection, and I don't feel like that's proper.
All right.
And it says here,
Paragraph
the court
46.
finds the paragraphs were gifted $40,000. You said yourself that the court acknowledges my grandfather gifted that to me, and then
Okay, we're on the objection to paragraph 46 currently. What's the objection there? That's a standard.
that's what I'm saying, Your Honor. I'm getting ready to provide the court all my objections and how they were manipulated, and a lot of them not objected to, when they clearly.
I see nothing wrong with paragraph 46. I'm going to continue to have that included in the decree. Paragraph 16, child support worksheet. I know there's some dispute about whether the court's imputed income numbers. However,
We skipped paragraph 48 that I have objections to that weren't submitted.
all right, just a moment. 16. Again, Ms. Schooler, I'm going to reserve ultimate judgment on the propriety of the child support amount based on the court scrutiny of your worksheet, which I don't have. So I at this point, I cannot make a final ruling regarding 16. I trust that you have provided documentation of the child care costs.
I know my client testified to it. I believe I did, but if not, I can absolutely submit it.
All right, please do. 17, object to the permanent parenting plan, joint legal custody should more specific.
And I
Okay,
did make that correction.
all right, fine.
She
17
submitted
is
Rule
so-
170 that I was misguided from my client on, or my attorney on. My attorney told me that he needed my objections to this journal entry. And they let Rule 170 slide right past me. And she stated in Rule 170, I believe that the respondent was granted sole legal custody
That's consistent with the court's ruling.
Look at Rule 170 compared to what the journal entry.
I don't know what you're talking about, Mr. Presbill. So,
I'll lay it out for you.
all right. I think the court has ruled on Mr. Wood's objections.
And then comes a brutally blunt and over-the-top remark that perfectly captures the frustration in the room, basically implying that if ruling on the objections means completely shutting them down in the harshest way possible, then yes, the court has definitely made its stance clear. It's a moment dripping with sarcasm and intensity, highlighting just how one-sided things feel from his perspective, while also underscoring the judge's firm and uncompromising control over the entire situation.
Ms. Guler, there's some minor modifications that need to be made to the decree before being submitted.
Can we address paragraph 48 for a minute?
All right. What would be wrong with neither party shall post sexually suggestive photographs or videos on social media or the internet? What's wrong with that?
Nothing, because I didn't object to it.
I thought you just said you wanted to address paragraph 48.
I'm on the journal entry of judgment and decree of divorce.
That's what I'm looking at.
Okay, maybe I had some paperwork. 44, I'm sorry. I stapled my papers wrong.
It's an award, making certain findings.
It states in there, F, respondent shall receive no less than $11,000 with their accrued judgment interest and up to 1/2 of the total proceeds of the sale of the real property. I feel like the wording has been manipulated there to override your ruling. You said that I was awarded the property and that I had until August 31st to pay that $11,000. And I'm willing to pay it in full once this journal entry is finalized.
Okay, so what's the problem if you intend to pay it off?
Ruling.
Excuse me.
Because the wording in there, her wording in there says that the client is still entitled to half the price of the property.
No, it's either or. If you pay it off, $11,000 plus interest by the August 31 deadline, then there's no purpose at that point to the language regarding sale, because a sale wouldn't be necessary at that point.
What's keeping if you retire in a couple years, what's keeping them from bringing this journal entry before another judge that didn't make that judgment and has no idea what's going on? They just have this wording to go by. This wording in paragraph F states that the respondent gets $11,000 and half the price of the property.
Your Honor, what I think would help is if I indent D, E, F, G so it shows that it's falling under the August 31st to discharge the lien, because D says if he fails to do so, I can indent it so it shows what happens if that August 31st deadline is not met. I think that would make it a little more clear. I don't mind doing that.
It wouldn't hurt if you'll make that change.
Absolutely.
So there's two options there. By August 31, he can pay $11,000 plus accrued interest and buy her out. He can do whatever he wants with his property at that point. But if he doesn't pay it off by that date, then it goes to the sale provision.
Or buy her out. What do you mean by that?
I think the wording is fairly obvious.
And by this point, the frustration in the courtroom turns almost sarcastically comical, because no matter how clear or obvious the judge makes things, it just doesn't seem to land. The tone shifts into a biting remark, basically suggesting that unless the ruling is spelled out in the most exaggerated, impossible to miss way, it still won't get through. It's a sharp, almost mocking moment that highlights just how disconnected the understanding has become, while the judge continues to press forward with unwavering patience and control.
You stated that I give her $11,000 and I'm awarded the property.
Plus interest. Yes, that's correct. If you get it done by August 31st.
Yeah, okay.
Correct. Okay. So the real question that remains before this court is Mr. Wood's involvement in the finalization of this journal entry. This court's point of view at this juncture would be that I think it's a professional responsibility that was previously imposed on this lawyer to sign off on what this court believes to be an accurate reflection of the court's rulings. Ms. Schooler, I trust you can address this relatively quickly.
Yes, Your Honor, I'll do it right now. The only reason for my objecting was I need that documentation, and based off of Mr. Perez-Beal's email, I don't think it would be best for me to have direct.
Here's something else that I'm going to ask you to
I
add.
want to wait until we have the transcript.
All right. Ms. Schooler, I want you to add a paragraph at the end of this journal entry that says that effective upon the filing of this journal entry and decree of divorce, Ronald P. Wood is withdrawn as counsel for the petitioner. But I do want Mr. Wood's signature on the document. It does not require, in this instance, Ms. Schooler, the signature of either one of the parties. So take
How
that
can
off.
you say that?
The journal entry is just meant to be a reflection of the rulings of the court. The attorneys have the authority to sign off on that. And the parties themselves slow up the process. So
this is our divorce, and I'm not agreeing. That's a contract, and I have to agree to it.
Can you give me some realistic appraisal as to when you can get this to Mr. Wood?
I will work on it right now, Your Honor. I can probably have it in 30 minutes.
Because I would love to have this in my signature queue by tomorrow.
I will have it to him in
Today.
30 to 45 minutes. I just want clarification. Am I removing the party signature lines from the parenting plan as well?
You are. Oh, yes. Because that's a parenting plan and not an agreed upon parenting plan.
Yes, Your Honor.
Is that
Yes.
legal?
Yes.
Your Honor.
And your child support worksheet will need to require this court's specific approval.
Yes, Your Honor.
Okay.
Your Honor, can you
So that'll be
legally do
submitted in the
that?
queue for separate approval, but along with the decree. Any questions about that, Ms. Schooler?
No, Your Honor. I will have it to him shortly.
Okay. And then, Mr. Wood, if the journal entry that upon your approval of the wording that I think the court has settled today, when you put your signature on it, that and allowing you to withdraw as soon as the court approves thereafter, are you satisfied with that resolution?
Yes, Your Honor.
All right.
You just said that Mr. Wood, no attorney's signature has to be on that journal entry.
No, I say yours doesn't have to be on there. Nor does Sidney Simons.
Well, let it be on the record that I'm firing him. He don't represent me.
And just when things couldn't get any more chaotic, the reality hits. He's trying to fire an attorney who has already withdrawn, making the argument completely pointless from the start. But here's the twist. The judge hasn't fully finalized that withdrawal yet, holding things in place until the requested clarifications to the journal entry are properly reviewed and approved. It's a moment that perfectly sums up the confusion on one side and the structured control on the other, as the court ensures everything is handled in the correct order no matter how much resistance comes along the way.
Court's already made its ruling. He's responsible for signing off as counsel of record as to what happened at the time of trial. Then he'll be allowed to withdraw at that juncture.
How does the court respond to him not? He didn't, Your Honor. A lot of my objections were manipulated
Well,
to make my objection sound stupid and invalid.
if you believe that you should have appropriate legal remedies in this case, following the finalization of this decree, I suggest that you get legal advice from a new attorney and follow that attorney's advice.
Are you going to
That'll be
take
my
any
suggestion.
disciplinary actions into him filing a false motion to withdraw?
I don't know how you can call his motion withdrawal false.
Because I'm going to supply with the court a transcript and then audio of him trying to extort money from me and saying that if you don't pay, I'm going to have to withdraw, and then turning around and filing it for what he did.
Your Honor, I said in the motion to withdraw that we had a difference of opinion in the matter, and we do still have a difference of opinion. And as far as appropriate course of action going forward, we disagree on that also. Those are the reasons.
Your
Which
Honor,
are legitimate reasons to seek withdrawal.
Mr. Woods, what are you going to say when you find yourself in court having to testify to our phone conversation?
All right. Well,
It
we're not
is
going to
what
get
it
into
is.
that. All right, Ms. Schooler, I think you have all the direction from the court that's necessary to finalize the journal entry and decree of divorce and child support worksheet. Is that correct?
Yes.
Your Honor, are you just going to overlook that Miss Schooler had a witness lie on the stand in your courtroom?
That is not an issue before the court at this time.
It is. I objected to it, but it was not submitted.
All right. The court's rulings made from the bench in Elk County stand with the clarification orders made by the court on the wording of the journal entry and decree of divorce. So I think, counsel, that essentially addresses the issues that need to be addressed. And therefore, at this time, this proceeding is currently in recess. I will look forward, Ms. Schooler, to receiving the journal entry, decree of divorce, and new child support worksheet and parenting plan here shortly, perhaps even today. Greatly
It'll be in
appreciated.
Mr. Woods' hands after 45 minutes, so just
All
don't
right.
hold that over me.
Let's get this wrapped up as soon as possible.
Okay.
All right.
Thank you, Your Honor.
All right, guys, that's where we're wrapping things up for today, but this story is far from over. It looks like there's at least one more hearing coming up, and unless he manages to bring in a new lawyer, he'll be stepping into that courtroom completely on his own next time. You already know that's going to be intense, and I'll definitely be covering it as soon as it happens. So if you enjoyed this video, make sure to like, subscribe, and stay tuned. You won't want to miss what comes next.